Caveat emptor in Nigerian law, limitations and exceptions. Mr. Ibrahim bought a new laptop from a retailer in Abuja, but it turned out to be a refurbished model. When he complained, the retailer refused to refund his money, citing the caveat emptor principle. However, the court ruled in Mr. Ibrahim's favor, stating that the retailer had misrepresented the product and therefore the buyer was entitled to a refund. The court's decision reflected the growing trend of protecting consumers' rights in Nigeria. The principle of caveat emptor, meaning let the buyer beware, remains a significant doctrine in Nigerian commercial law, especially in contract law, sale of goods law, and increasingly in consumer protection jurisprudence. While historically buyers bore the risk in transactions, Nigerian courts have gradually shifted toward consumer-centric protections reflecting global legal trends. Instances when caveat emptor applies. 1. Second-hand goods. When buying used or second-hand goods, the buyer is expected to inspect the goods carefully, and the seller is not liable for any defects. 2. Auction sales. In auction sales, the goods are sold as is and the buyer is responsible for inspecting the goods before bidding. 3. Private sales. In private sales between individuals, the buyer is expected to take responsibility for inspecting the goods and negotiating the price. 4. Goods sold as is. When goods are sold as is, the seller is not liable for any defects, and the buyer takes the goods in their current condition. Instances when caveat emptor does not apply. 1. Consumer protection laws. In Nigeria, consumer protection laws such as the Consumer Protection Council Act provide protection for consumers and impose liability on sellers for defective goods. 2. Implied terms. In contracts for the sale of goods, there are implied terms, such as the implied term of fitness for purpose, which imposes liability on the seller for defective goods. 3. Misrepresentation. If the seller makes a false representation about the goods, the buyer can claim damages or rescind the contract. 4. Goods sold with warranties. When goods are sold with warranties or guarantees, the seller is liable for any defects or failures to perform. 5. Unfair contract terms. If a contract term is deemed unfair or unreasonable, the court may strike it down, and the seller may be liable for any losses incurred by the buyer. Have you found yourself in a similar situation to Ibrahim? Let me know in the comments.
Just meeting me or reading my write-up for the first time? My name is Deborah Worry. I am a lawyer and an author.